Hello everyone. So can we start the meeting? Sir, are you there? Kalyan sir?
Yes.
Okay. So I would like to start this webinar by telling the topic of this webinar, which is the importance of legal research and writing. And this webinar is conducted by LawSIkho. Today with us we have Sir Kalyan Jhabang, who is a partner at Surana and Surana International Attorneys. We would like to welcome you, sir. Right now, we have Dipshi ma'am with us, uh, who is also the legal editor and coach at LawSIkho. She is a lawyer by profession and an enthusiastic social worker and passionate about teaching. I would like to start this webinar by speaking a few words about Sir Kalyan Jhabang. Sir has been practicing advocate since 1990. He is a certified independent director and a registered patent agent. Sir has advised several large international domestic clients for their corporate, commercial, insurance, intellectual property, and dispute resolution requirements. He has also conducted various landmark litigation cases before various courts like Supreme Court of India, Company Law Tribunal, National Green Tribunal, Domestic Arbitral Tribunal, Consumer Forums, Debt Recovery Tribunals, and High Court of Madras, Karnataka, Kerala, Maharashtra, Punjab, Haryana, and Chhattisgarh. Sir has also been negotiating and drafting complex domestic and international commercial contracts, scheme of mergers and amalgamations, IPR licensing agreements, sale and lease agreements, etc. He has been the sole arbiter in several arbitrations. He has also successfully mediated and settled several commercial, corporate, family, and social disputes. I would like to welcome you, sir.
Thank you, ma'am, for the kind words. A good evening to all the esteemed participants who I'm told are joining this webinar through Zoom as well as live broadcast over YouTube, LinkedIn, and Facebook. A little about the firm. Surana and Surana has successfully completed 50 years of legal practice. About a little more than 2 decades ago, all the leading newspapers and magazines published the fact that our firm was Asia's first ISO 9000 certified law firm. We have the magazines Martindale, Hubble, and Asia Pacific Legal, which has credited our firm as one of the top law firms practicing arbitration and mediation, competition law, HR law, company law, commercial law, among other areas as real estate, intellectual property, family business, and defense. It is our pleasure to partner with LawSIkho, which is one of the most popular websites among law students and young lawyers who seek to upgrade their legal skills and fast track their career. I'm thankful to Shreya, who is moderating this webinar, and Dipshishwara for interacting with the students. I'm delighted to speak at today's session on legal research and writing, a subject very close to my heart. Legal research, in my opinion, is the backbone of a good lawyer and a good teacher. Here, writing would mean communication. Communication can be in written, oral, and nowadays in video form also. Let us be clear of the basic concepts of legal research and legal writing, or one should say communication. Starting with communication, I would just want to explain and clarify for all present. Communication is not what you convey. Rather, it is what the other person understands. And this we must always understand as professionals. Coming back to research, clear, unambiguous, and simple communication is vital in every area of legal practice. Whenever instructions for research are communicated, this must be very clear and focused. It is advisable to have the research mandate clearly written down and agreed between the senior and the researcher. The communication must be such that it should be easily understood by everybody. Doorman to chairman is a terminology which I would use often. Here, let me give you an anecdote. The famous French Emperor Napoleon, among his various contexts, whenever he would win a battle, would personally draft a treaty to be signed between him and the losing side. Once drafted, he would call and read it out to his doorman. Then he would ask the doorman to explain his understanding of the treaty. If the doorman could explain to Napoleon what he understood from the treaty, then only Napoleon would give it to the losing side for signing. And this is exactly what I mean from doorman to chairman. That must be the simplicity of your writing. The word research in today's context brings to the mind keyword research on popular platforms like India Kanun, SEC Online, Manupatra, and so on. Researchers today straight away get into research platforms to search for relevant citations and legal provisions. I believe this must not be the first step. Rather, it must be the last step of the research process. Research means revisit. That means to research. You have to search, search, and search. In any case or any transaction, I would expect my junior or researcher to first master the facts in a chronological order. Thereafter, dissect every fact by picturizing him or herself being in the position of the client or the victim or the other side. This process will give multiple meanings and multiple colors to each fact. This multiple meaning and multiple colors must be noted against the respective facts which are already listed in chronological order. After they go through the revisiting of facts, they must also look at similar situations from social, administrative, legal, and other points of view, as the case requires to better understand the case. This process will give an insight into how the opposite party, the judge, and others would view the case. Thereafter, the researcher will get clarity on what is the proposition of law that requires to be gone through. I would always advise my juniors to take the Black's Law Dictionary and Ramaya Law Lexicon to better understand the propositions of law in the first step. Once we are clear about what the exact proposition of law is, favorable or unfavorable, then we should look at citation search, which will now be very focused and throw upon more relevant data. After analyzing the most relevant citation, the researcher must prepare a note which uses simple words, simple sentences, unambiguous language to present the propositions of law. That is a 4-line summary of each citation relevant for each proposition. I would like to give you a picture of the entire process of research to have 3 parts. First, you research, you analyze, then it comes to writing and communicating your research findings. I would like you to visualize the entire research and writing process as a manufacturing process, where research is the raw material, analyzing it is the processing, and communication is the result. Findings must be the finished products. That all has to synchronize. A very high quality raw material with average processing quality will give me an above average product. Average quality of raw material with excellent processing can also give you an average to above average finished product. I'm giving this analogy to impress upon you the importance of good quality research and good quality analysis to lead to good quality of communication and research findings for a successful professional. For a researcher to be effective, he or she must read widely on a daily basis, not only about news, laws and judgments concerning his or her area of practice, but also information relating to government policy, as well as development concerning the sector in which their clients operate. I would also recommend this researcher doing research process puts effort on interdisciplinary research. That is to get various interpretations of the legal proposition from other areas of law. For example, how are the terms of a commercial contract interpreted by commercial courts, whereas interpretation of an employment contract by labor courts, interpretation of licensing contracts by the intellectual property courts, and so on. You will be surprised that you may find many favorable interpretations of the proposition of law you are relying upon from the other disciplines. Once research and detailed analysis of the research is done, what the researcher writes or analyzes the research findings, it is important to do homework to better understand the decision maker. That is, a judge in a litigation or the counterparty in a negotiation. If you get an insight into the personality, likes and dislikes, the ideology of the decision maker, this will help you mold the research findings in a manner which will appeal to the decision maker at an intellectual as well as an emotional level. And that is why it is important to know the decision maker too. When presenting the research findings, an intellectual researcher will place multiple possibilities, solutions before the decision maker, and then move on to present logical but obvious shortcomings in all presented solutions except one, which you desire the decision maker to accept. That will be the last solution which you give. A good researcher must also be a versatile storyteller. He or she should be able to expertly interweave the relevant facts, legal propositions, favorable interpretations into a fabric which would appeal to the decision maker. In a strict sense, it is understood as limited to those works which contribute to legal science, that is excluding materials as textbooks and casebooks as far as research is concerned. Now, in my view, this is too narrow a view of research, and we need not adopt such a restricted definition of legal research. To advance the science of law, it is necessary for a researcher to go into the underlying principles or reasons of law. The legal profession, judges and teachers, have a heavy task of understanding and applying the manifold laws properly and correctly, and also to guide the legislators in framing new laws. The need and importance of law research, therefore, cannot be overemphasized, particularly in our society committed to democratic values and achieving socio-economic justice for the people. Now, research can be divided into a narrow view or broad view. In a narrow view, most students and even lawyers, they have a narrow view of research in the sense, to them, research is LexisNexis, Supreme Court, Manupatra. Good research, however, is more than just a research system. It is a process which you need to follow. A broad view of research is the key to success in researching legal issues is realizing that research is a process. You cannot memorize a million cases and you cannot look for a needle in the haystack, but you can master the overall process of research. Once you have mastered that process, you can complete almost any research assignment with confidence. Good general research is intertwined with analysis, understanding, and application. While finding the law is important, one has not truly found the law until he or she understands it. I repeat this again. One has truly not found the law until he or she understands it. There are various methodologies of research. I'll just read the headings: quantitative, qualitative, mixed methods, review, comparative, doctrinal, but I think LawSIkho would take care of that. I'm not getting into those details. One of the things which I would like to place over here is a unique aspect of legal research is that often there will be no clear answer to the question you are researching. Instead, you will find pieces to a puzzle, and you will have to use legal analysis to fit the pieces together. Legal, of course, does not terminate once an issue has been identified or relevant cases have been discovered and a rule of law determined. Rather, the researcher effort must proceed until the lawyer has a thorough understanding of the rationale and reasons behind the formulation of the rule. There are some ethics with research. Very often, researchers face issues with plagiarism as an act of using another person's work without appropriate acknowledgement. If you have presented another person's work as your own, you have committed plagiarism even if you did not intend to do so. Let me leave you with a mental picture where the facts, the research, the analysis, and the presentation can be viewed as different strands of thread which an expert weaver would bring together to make a fine piece of fabric. The quality of research, that is each thread, would contribute to the strength, the softness, the texture of the fabric. As a good researcher, you must place yourself in the shoes of that weaver to weave a fabric that appeals to the judge and to the decision maker. With this, my thoughts on a research I would end. I look forward to questions from viewers on this topic.
Thank you, sir, for this insightful information. I would request all the attendees to put your questions in the Q&A box so that we can ask sir those questions. So there is one question from a first-year law student. He is asking, how can I start research work as a fresher in law school?
You're taking me back years back. Okay, as a researcher in law school, whenever you come across any proposition, first, as I said, understand what the proposition is and then start looking into the case laws. Most of us just do the Google search or get into the keyword search, take out the case laws and don't understand even the very basics. The basics is the foundation and the basis on which the entire thought process of the law you need to understand. So whenever there is any issue which comes in or any topic which comes to your notice or any case law which is reported in the newspapers, please get to the very basics of why the law and how the law evolved and what its present stand is. I think that would be a best way to do your research.
Yes, sir. We have another question. So what will be the best methodology for following research papers?
Diksha ma'am, would you take that?
I was on mute. I'm so sorry. What was the question again?
What are the best methodologies for following a research paper?
Okay, so it depends. I mean, what kind of a topic that you have chosen. First of all, it will depend on that. Okay, so for instance, if it's a very detailed analysis and you want a descriptive kind of writing for that kind of a topic, you should go for secondary research. So you should look for articles which have already worked on that topic. You should look for the gray areas that the authors, they have not touched in that topic. And accordingly, you should build your hypothesis and the research questions on that particular topic. But then if it is something which is very, new and something which is very empirical, and that you want to understand from the audience, you have a target audience in mind that I should approach a few people and I should conduct interviews and observations, then you go for a pure empirical research, that is a pure primary research. So it will depend on, it will differ from topic to topic, and in a few cases you can combine both of these, right? You can even have a secondary research and at the same time you can have your interviews and questionnaires alongside. So it will depend on your topic.
Okay, thank you, ma'am. So the next question over here is, what is the main aspect of a successful research while drafting a petition? Sir?
Yes. First, as I said earlier in my speech, you need to get the factual chronological events in place. Most of us jump to doing the research and doing the drafting without reading or rereading the entire facts again. Just to share an example, a few years ago, we had a case where the tenant had come to us on the verge of being evicted. And one of the main documents which the other side had was a plan which they say was been signed by our client. It was only on closer scrutiny of the document presented that this was in 1909. The document is dated 1909. Chennai had become from Chennai to Madras, from Madras to Chennai in 96. And in the page 1, it said Chennai, and in page 2, it said Madras. And then we started up the entire thing of calling the persons for getting into them to be interviewed and for them to be brought to the box. And we were able to say that this document is fabricated. So in that context, first, before you draft any problem, please get all the factual details straight in chronological order. Then fix your proposition of law before you start any research. Please do not start your research without getting these two things straight.
Okay. So there is another question. I'm just putting it in a short form. So what will be the ideal structure for any article? Like we, generally read about questions and everything, but then what kind of structure should we formulate for writing?
Diksha ma'am, would you want to take that from students' perspective?
Yes, so I think for a LawSIkho students, one of the first and basic things that we start with is how to go about structuring your article. Okay, so the first thing that I always tell them, that once you have your topic in mind, frame at least 2 to 3 important questions around that topic, because you cannot address everything under the sun in that particular topic, and it becomes very distractive for you also and for the reader also. So frame 2 to 3 important questions. Once you have done that, then you know that under these 3 questions I need my headings and subheadings, right? So you start with introducing the topic. Introduce what is the objective, what is the purpose, why you have chosen this topic. Write about that. Give an outline of what are the important areas that you are going to cover under this particular article. Then come on to your 3 relevant questions that you want to answer, divided into headings, subheadings. You can give bullet points. Okay, and finally conclude it. So in conclusion, you summarize all your findings. Okay, because some people only write the conclusion for the sake of writing it. Do not do that. Summarize all your findings and then give a takeaway for the reader. Suggest a few points that the reader can take away with him. Yeah.
Okay. So this will be the last question, and then we'll move forward for the webinar. So how to bridge the gap between a gray area of law where you hardly have any case laws or information available. So how do you write on that particular area of law?
Yes, this is a good, interesting question. And this is where one of the things which I said is you need to look into multidisciplinary areas of law, and you will invariably find some writing or something or there which will give you a guidance. It is a jigsaw puzzle which you need to put in place, and then you analyze. I think one of the things could be like when some country says, I'm going and capturing the moon and I will start mining the moon. So is there any law on that? No, there may not be any specific law, but you need to start learning about the international law. You need to see how the oceans, how the system came about, the property law going on further. Apply your mind to that, see how it will come as part of the common pool, and it will be for the general good of the society. You will have to start applying the law, use your analytics, and then you come up with an answer. So it is you, and as I said in my speech earlier, in all the researches, you're not going to find a clear-cut answer. Sometimes you'll have a lot of gaps. And this is where your analysis play a major role, and you'll get into various disciplines to start taking it up.
Thank you so much, sir. So now we'll move forward for this webinar, and then we'll take the Q&A questions after the discussion forum. Yes.
The other part is, I think, of legal writing. Now, the legal profession swears by the maxim, I hope I get this right, verb voluntas scripta mane, meaning words, spoken words fly away, written words remain. A well-drafted document is equivalent to a strong argument and can make or break a case. A legal document, whether it is a contract, a plaint, a written statement, a counter, an affidavit, they serve 2 purposes. One is informing and engaging both the client and the court about the legal issue. It becomes essential for lawyers and judges to draft all legal documents with precision, to clearly decipher all essential facts, as well as engage a layman to its content. So that is what I said in the beginning thing, from a doorman to chair. Legal drafting skills are important as they ensure that the legal document is structured properly. An unstructured document without balance lacks effectiveness. Overusing negative statements or an aggressive tone can make a document seem confrontational. A document free of such failures and errors is considered most authentic and effective. Legal drafting skills embody refraining from using complicated legal phrases and jargon that is beyond the comprehension of a layman. A legal document burdened with unnecessarily complicated terms loses its essence as its purpose becomes unclear. Legal drafting skills also include the art of drafting authentic documents rather than using template formats for every contract or notice. It is important that every document drafted by a lawyer is free of plagiarism or unverified, unauthentic content. Each statement must be supported by a case law, precedent, or statute. This makes conducting legal research necessary before drafting a document. One of the skills required to draft a pristine document. Research is necessary. It is essential to construct a background and basic structure, and this enables the code to relate to its content effectively. There are concerns with legal writing. Now, in a survey which had been conducted in America, the members of the academy, bench, and the bar were asked what they thought of the writing skills of law graduates. The complaints received were mainly this: too much of verbosity, lack of focus, incompleteness, failure to grasp issues, poor grammar, lack of basic writing principles, lack of clarity, and lack of overall organization of the article which you are written down. So these are things which you must avoid, and which had been rightly explained in the question answer session, which you need to do. I'll go a little further on that. Now, why a legal document needs to be well written? Well written means that it accomplishes the writer's purpose and the intended use. Both needs to be accomplished. On a clear introspection, this theory does not provide an adequate account of the concept of good writing. For while it is correct to say that a document enables the writer's purpose to be an effective document, it does not necessarily mean that it is well written. Conversely, a document can be well written, though it does not advance the writer's purpose. If it is a brief, has a weak legal argument, it is unlikely to persuade the court, even if it is otherwise well written. So this would be a little thing. Now, understanding the concept of good writing is to look to the needs and interest of the reading audience. I think that is most important. After all, whether a piece of writing is regarded as well written is a judgment of the reader. It does not depend on the writer's own assessment of the work. Good writing simply means writing that fulfills the expectations, that is, satisfies the needs and interests of the intended audience. The legal reader's purpose for reading the document is to extract information that will facilitate decision making. A document is well written if and only if the writing facilitates that decision making and helps make decisions in the course of their professional duties. A lawyer equipped with legal drafting skills is able to identify his target audience. The concept of a legal document must be understood by the audience who is reading it. A legal notice sent to the other party must not be full of legal jargon that the other party is disabled from understanding the legal issue and remedies sought from him. A few fundamental qualities to enable good writing. The first one is good legal writing is clear. Just to give an example, a partner reads an associate's memo in order to gain a better understanding of the legal challenges facing the client. Similarly, the judge reads the brief in order to understand the facts and the lawyer's arguments. In each of these scenarios, the reader's objective will be frustrated if the reader cannot understand the writer's message. Hence, clarity is the key. Clarity requires proper conventional grammar and punctuation. Generally, greater the deviation from the core rules of grammar, the more difficult it will be for the reader to understand the writer's message. Another method to maximize clarity is to use ordinary words, simple sentences, and same plain language. That is a key. In fact, recently, the Supreme Court Justice M.R. Shah while hearing an SLP stated, he had to use tiger balm after reading an incomprehensible judgment passed by a division bench. I'm sure a researcher should not end up giving a subject like that way. In contrast, we had the Punjab and Haryana High Court recently say, where they approved the judge's use of simple language, observing simple language is the strength of any writer. Many of us get carried away by using bombastic words. No, to write in simple language takes a lot of effort which you need to do to understand the concept. This is in the judgment of Praveen Bali versus State of Punjab. In fact, I remember when I first was taking up with my senior year, and I wrote him a 3-page note on the case. He just tore it in front of me, and he said, "Bring me a 1-page note." And I broke my next 2 days to make it a 1-page note, believe me. So that should be the simplicity of writing. And that makes it concise. And that is why I say good writing, legal writing is concise. It is, no, conciseness is often confused with brevity. There's a lot of difference. But concise writing is not merely brief, rather it is efficient. Concise writing conveys the writer's point lucidly, without superfluous words, with an appropriate level of detail. Concise writing is writing that is as simple as possible without unduly restricting the amount of information conveyed. Good legal writing is engaging. Good writing, as opposed to merely competent writing, also engages the reader. It is crisp and powerful and compels the reader to keep reading. Many of you would have observed it when you're taking up a novel. Some novels you read from cover to cover, and some you just leave it after a few pages. It encourages the reader to engage with the material by agreeing with it, disagreeing with it, reconstituting it in the reader's own ideas. In other words, writing that is engaging stimulates the reader's thinking. And it is this quality that separates truly good legal writing from merely competent legal writing. Then we have the art of persuasive legal writing. Have something to say. It is not that you have got to have something to say. It is that you have got some. It is not that you have to say something. It is that you have got something to say. This distinction is very important. You don't say something just for the sake of saying it, but you must have something which you really want to say. Writing a brief is like a lawsuit. You start with your theory of the case, the basic idea that explains not only the legal theory and the factual background, but also ties as much of the evidence as possible into a coherent and credible whole. This means making choices. You make choices between inconsistent legal theories. You cull out weak points. You discard what doesn't need to be said, even if it doesn't hurt. While writing, think first, write second. One of the easiest ways to obscure your theory of the case is to get caught in the word processor trap. The ease of the electronic editing has given some people the notion that you ought to write everything down, no matter how jumbled. Just get it into the word processor, then you can fix it and clean it and cut it later, even shifting a whole chunks from one place to another. Deleting entire sections of a brief seems to be a wasteful exercise of energy, especially after you have taken all the time and effort to edit and polish it. One of the things in writing is you must realize you are telling a story. Humans have always used the story to understand facts and resolve issues. Everything in law is a story. Every case, every motion, every brief is a story. The winning brief needs to tell a persuasive story. While there are lots of ways to write a statement of facts, a good one passes two essential tests. First, it stands alone. Anyone reading a statement of facts should understand what the case is about without having to look at anything else. Second, the statement of facts should make the reader take your side. It should be persuasive without being argumentative. Understate rather than overstate. Better yet, don't evaluate at all. Let the reader do it for you. Make sense out of the law. Principles only have meaning in the context of actual events. In other words, it is every rule is a story. Your job is to tell that story so that it compels your reader to apply it the right way. Good common sense is a great leveler. Some ideas sound almost unapproachable when they are presented as good pronouncements. Authentication is no cure for irrelevance. It is stated more comfortably in everyday language. It doesn't matter how reliable the proof is if it doesn't have anything to do with the case. You remove all the clutter. Take advantage of context. It is impossible to make each sentence a completely accurate statement of law, so don't try. Get the facts straight. Make every point a good one. A brief is not a treatise. Every point should count. Resist the impulse to put your reader through everything that you had to go through to write the brief. Make your writing stand out. It is not enough to make good points. You need to make your points good. Here are some ways to do it. First, have a theme, a strong central idea that keeps surfacing because it underlies everything you have to say. Second, start strong, end strong. Even though you're determined to make only great arguments, start and finish with your best ones. Finally, illustrate what you have to say. Every point worth making is worth making well. Every point worth making well is worth illustrating. One simple example sticks better than a whole book of abstractions. I would say this. People today says that research and writing must be volumes and volumes. No, it is not volumes and pages that count. It is your essence that you put across that really counts. And with this, I would be open for questions.
Thank you, sir, for this insightful speech of yours. Now I would request Dipshi ma'am to take over for the discussion forum, and then later on we'll have the questions all together.
Thank you so much, sir, for such an enlightening session. I think all of us are going to take away a lot of insight and a lot of information back with us. So I am going to put forward some very simple questions that, as students, all of us have in our mind. First of all, like students know that they have to write articles, but what kind of articles should they aim for when they're trying to write for maybe some knowledge management platform, or if they want to write for some law firms or some reputed journals for that matter of fact? What kind of articles, what themes should they pick up for that?
Most of us would not be interested in history. It doesn't mean that you should not write anything about any old article. You need to write about current topics, current judgments. That is where the interest lies, where people really would want to think. You may write how something has been wrongly interpreted by the courts or a judgment and give about that, but it needs to be something current, and that is how you need to choose your topics. Or it can be something even futuristic. So those are the topics which any law firm and I'm sure most of the magazines would look forward to receiving from the students. That is what you need to look for.
Yes. So something which is very current, which is latest, which readers want to know more about. Right. So second thing would be, do publications matter? Because, once we get into law school, there's so much going around, the new subjects and there are moot competitions and, somebody wants to do internships, litigations, law firm, there's so many things. So how do they decide that how to give prominence to legal writing and research in those 5 years of law school?
Legal writing, if I may say so, as a law student, one, you're mostly doing it all alone. You don't have company. You don't have anyone seeing it while you're doing it. Unlike in a moot court, when you have work in a group or in any other activity which you do it. So most of them think that this is a library job, it's a bookworm job. No. Legal writing will clearly show whether you have understood the proposition of law in the first place. Have you been able to analyze? Have you been able to weave the threads that you have analyzed into a fabric which is presentable? And this is something which, end of the day, you are not going to just be mooting all around the moment you come out from college. You would have to start writing, whether it is contracts, whether it is reviews, whether it is complaints, whether it is in the court. You would need to start writing, whether you're issuing notices. So reading, doing all the other activities is, I would say, the colorful part of it. But writing is an essence which is very much required. Because if you do not have the practice of writing, then you end up writing volumes and volumes. I said you what the Americans said about new lawyers, the 5 different things which they have a shortfall on. That is where you cut an edge above the others if you have practiced writing. Because as I said, when my senior itself, when he tore up the 3-page note which I had written and said, give me a 1-page note. Believe me, it took me 2 days to make that 3-page note to a 1-page note. So it is not easy, concise and write without missing out any point. Because if I had missed out, I would have had it again from my senior. So I had to be doubly sure that I write concise and precise. In that 1 page, I was able to convey the entire thing. And this will come only from practice and practice alone. Today, with the computer world coming in, we all get into the cut, copy, paste system, which does not really give us the analytical mind which we must have to fit a jigsaw puzzle in place. And that is why I would say, yes, it is not a very glamorous part of it till it comes out in the news, in the print or any media or any of the journals take it up. But this is something which will stand you in good stead the entire life. But please get into the habit of writing.
Right. Thank you, sir. So also, okay, even if a student starts writing, develops a practice, and now he can see that, he can get published now, or prints are taking his articles. So then should he concentrate on profile building, as in, should he choose a particular theme that, I should only write on corporate or only write on M&A, or should he explore different areas to show that he has a knowledge of all round legal system of India?
I would say you concentrate on any one subject unless you really like that subject, and that is your passion. You write it out of passion, then you stick to one subject. Nothing wrong in it. But personally, if you ask me, you are, as a researcher, you have nothing fixed. You are open to anything you are willing to research. You follow the process, you do the entire thing. You must be able to write in different articles, in different areas and different subjects too. That will widen your knowledge. And also make sure that the people who see you will see you as much more versatile and say, here's a person who can do my work and get my job done, whatever be the situation.
Okay, sir, got it. Also, sir, building a career in legal writing was not seen as a very go-to option until recent times. So do you think that the scenario has changed now? People can come and actually build a career in legal writing?
I would say yes. Maybe because of the old school of thought in the first place, but the current situation where even the governments would want persons to help you analyze and write the drafting of the laws. One of the best examples would be the IBC. In fact, most of the persons who you have there are youngsters who have been helping them write in their 20s and 30s. And that is something which I would never expect about 20 years back, where persons who were drafting the laws were all people who were all 50 plus. So today you have a huge career, and if your writing is explicit, I'm sure it will do very well for all.
That's some encouragement for all of us. And so at the last, I think I would want to ask that a lot of students get confused when they initiate their legal research or even an article writing, that fine, I have to frame 2-3 relevant questions, but how do I go about framing those relevant questions? What should the relevant questions focus on? If you can throw a light on that.
That would be rather like, what is it that you're wanting to convey in your article which you're wanting to write?
Okay.
So you frame your question based on that. So unless you're clear what is the subject you're going to write upon, what is the topic you're going to touch upon, your questions will have to be framed on that, and then maybe you give it a variant this way or that way. Your questions may vary later, but you need to be clear about what is the topic you're going to write upon and what is it that you want to convey to the end user. Then accordingly frame your questions.
Okay, all right. Thank you, sir. That will be enough from me. Shreya, now you can take it.
Thank you, ma'am. Thank you, sir. So there's one question that was coming up that, I mean, everyone tells that you should keep the audience in mind when you start writing and everything. But then what kind of audience should you really keep in mind when you're writing an article? Like sir said that you should focus on the recent cases. So should you focus it on overall everyone, or especially the lawyers who are focusing on that part? Like if I'm writing a article on takeover or M&A specifically, then should I focus on only those lawyers who will be reading my articles, or those students who will be reading my articles, or should I make it for the layman? So how should we keep in mind the audience?
It depends in where your publication is going to be put. If it is going to be put in a law journal, read by most of the judges and the lawyers, I would not expect a layman's language article to come out. But if I'm expecting it to come out in either the social media or in a magazine, any of the other periodicals, if I'm going to use high-flying words and all the technical jargon, believe me, most of them will not be reading it. So that is why you need to be clear about which is the audience you're going to address. Once that is clear, you choose it accordingly. And it is always the case that it is the audience who would choose what you write and how you write.
So, sir, the next question in the chat box is, the legal aspects and the factual aspects are two different areas. So how to arrange them?
Yes. Well, I think basic concept is get your chronology of facts first. Most of us as youngsters who I see coming sometimes, they immediately take, sir, I've taken out 4 judgments, I've taken out 5 judgments, and they don't have their facts straight. So if you're not going to do that basic facts straight, believe me, it's on a shaky wicket which you're standing. So your facts, I would give prominence to you getting your facts straight, like the instance which I told you. If you had not got into the facts and had just fought on law, taken out case laws, I'm sure we would have lost the case by when. But because of that, we succeeded. Parties ended up in a settlement, negotiated, and we moved forward. And unless you get your facts straight, it is the facts to which you need to apply the law. You don't apply law to the facts. In the sense, you don't create the saying that the law is there, so that is why the facts have to be like this. The facts are unchangeable. The law is something which you interpret and you analyze, which you can always give a different interpretation. So most of us spend less time in getting the basic facts and chronology of events straight and jump straight into law. I think that must change, and that will be a big help. Okay. And then, as I also said, sometimes often we will not have a clear-cut answer. And this is where you use your analytical mind and try to put the pieces together.
Okay. So there was one question from my end. So, everyone tells that you should start writing and everything, but then do law firms really read publications, or they focus on internship mainly when they see a resume or CV? Are the publications really important when it comes to, internship or a job placement in law firms?
I think two ways of looking at it. One, yes, your internship, yes, the law firms, because the partners be so busy or the senior associates be so busy, they're looking at you doing the job down first. Do they look at the articles and just take you in? May not be so at all, but they do look at the articles, how and why they are helpful. If they see a number of articles written by you, they would expect you to do good drafting. And if they're sure that you would be a person who will do good drafting, so much becomes easier for them to give you work and get you to make you learn. And that is why I would say good firms look at the articles written and see how serious that article is. And that is why you must take up article writing also. It will help you in your internship to a major extent, because then that will give the partners and the other senior associates the confidence that here's a person who will be able to make a good first cut draft and come back to me.
Okay, sir. So, a similar question to this. Do you think there is an importance of legal research and writing for LLM programs?
Yes, I would say yes, that is.
Okay.
Dixie, would you want to step in more as a...
Yeah, so I mean, those who go for LLM, they are mostly into academics. So it goes without saying that for them to focus more on research and articles is extremely important, because they're doing dissertation, and then most of them want to go for PhD also. And PhD is like 4 or 5 years of your commitment on a particular thesis. So if you're not used to writing, what makes you think that you'll be able to complete that such a long thesis of 4 to 5 years? So yes, you have to be acquainted with legal writing and research if you want to pursue academics.
Okay, thank you, ma'am. Thank you.
Just to add on to what Dixit ma'am said, today, yes, even if it is not just for academics that you're getting into writing, believe me, it changes your perspective and the presentation which you make. It's a huge difference which we can see. So we have seen the difference very clearly of persons who have gone for the higher studies, who have done the LLMs, and the drafts which they give back to us once they have finished that course. There's a huge difference.
Okay. So, sir, there's a question from a student or attendee. So how should you select a topic for writing? And specifically, I'm interested in data protection law. Like, what are the specific topics right now in data protection law that you would suggest students to write?
I think Twitter is the best example that you can think of, where all it lands into. That's a live example. So you read what happens to your data, what is collected, what is not collected, what can be done, what cannot be done. No doubt we have the old ones are that of the Facebook and what all they collected. So today is a live topic. None of us realize that data is something so valuable and it is so much of money. Economically, apart from your privacy issues, believe me, it is a huge economic activity which is there.
So there's another question. If a lawyer is drafting a commercial agreement for a client who is not a lawyer, should you use legal jargon or the layman language?
I would, even if it's a person who knows law, I would still come back to my old thing of doorman to chairman. If the understanding is not clear, if it leads to interpretation and we lawyers are good at it, it will only end up in the contract or the agreement not working itself out well. It must be in plain, simple, clear language, which any person, I mean from the doorman to the chairman, must be able to understand it, and there should be no ambiguity. Because once there's some ambiguity and your legal jargon is there, then it becomes a matter of interpretation, and then it becomes a question of each one playing to their strengths. So I would prefer all documents to be in as simple language as possible.
Okay. So the next question over here is, do you think that the research papers and the literature gets burdened by the ideologies of the researchers or the writers?
Sorry, can you come again?
Do you think that the most of the research papers and literature get burdened by the ideologies of the researchers and writers than the actual factual, what the facts are?
I would say yes. In the ideologies of the researcher, yes, you do believe what you're writing. And that is why I told you must write it with a passion. You write it because you believe in it. You don't have an ulterior objective when you're writing. If that is an objective which you have now, I have an objective that I need to achieve this and that's why I'm writing, then that is wrong. But if not, the researcher writes what his or her passion says. They write from their mind and heart. And I think that is what you need to follow. And that is how we would sometimes get new laws. We would have the courts also changed their entire concepts. And all that has come because people have written so. The best example would be this IT Act Section 65B being repealed because of a student taking it up. Today we have the court's acceptance of a live-in relationship because this is something which has been written by someone who believes it. We had a high court judge over here who went to psychiatrists and others to understand the entire concept of this before he gave his judgment. So yes, today But the researcher must write from his passion. And I'm again repeating this. We write with a passion in mind, there's nothing wrong, whatever you write. It can be your views. But if you write with some other objective or because of to achieve some other objective, I think that's a thin line which we should not cross.
Okay. So, sir, there is a question regarding plagiarism. So, since you've already spoken on that, I would like to ask, how should one avoid plagiarism? Like, if there is something that, he has taken it from the other person, but he wants that to be written in his article. So, how do you avoid that? Or how do you contact that person, or what should you do in that case?
You write to that person, or you at least acknowledge it in your letter that it's in your article that it's taken from him. Believe me, at least in India, to make the articles, there's a little tolerance to it. But if you're planning to go to the West, if there's anything more than a 5% plagiarism in it, it's just thrown out. And today the softwares do the reading and give the notes out even before it goes to the other person's table.
Okay. So there's another question, like on what should you focus on in your law schools? Research paper, articles, blogs? What should be the main focus on which law firms look at?
Forget the law firms. In the law school, focus on your studies and all extracurricular activities which you do. Do it with a passion. You're not doing it saying that this is getting me my bread and butter. No, then you're not in the correct profession. You must do it because you like law, you love to be a lawyer. And that is what you must do. Everything else will fall in place.
So, sir, as you said...
I'm a little strong on this view. If we don't like it, we don't have a passion for it, we should not be doing it. Then you're in a wrong place.
Yeah. So, there's another question, like as you said that you should write in layman language, but how to unlearn a certain style of language which is being used by lawyers often? I guess this is a question by a lawyer.
So, I think what we should do, yes, we have this whereas, shall, all those words which you continue to use. It is going to be tough. It's not going to happen overnight. But believe me, when it gets into strict litigation, and if there is clear language, it saves the party, it's very clear. But when there's so much of jargon used, it can be twisted to either person's advantage, depending on who's the stronger person in interpreting it. It does take a lot of effort. You need to unlearn it. It comes slowly by practice. And if you have a mindset saying that I will use only simple language, come what may, it is possible. The clients usually don't ask for you to give some flowery language. They want the document in place as my concerns addressed. So that's about all. It is we who are not willing to take that step, and we think if I write in too simple a language, we will think that I don't know anything. I think that fear must get out from our mind, because it takes courage to write in a simple language.
Okay. So, the next question over here is, what are the things that one should keep in mind while taking a brief from the clients, since a good brief is what is required for a good petition. So, how you should go about keeping those things in your mind.
This, I think, is one of the most important things which must happen. And this, even whether it is for researchers and even whether it is for lawyers. When a client is giving you the brief, your mind must be blank. When I say your mind must be blank, in the sense, you don't go in with any prejudice, you don't go with any pre-notions, you don't prejudge your client saying he would have done this or she would have done this or something like that. You go with an open mind. You must note down every detail and get it in chronological order. Relevant or irrelevant, do not apply your mind then. Get all those facts straight in chronological order. Just to share with you all one of the instances which happened. We had a client, it was a corporate. Things had gone bad in the joint venture. One of the only things which they said in the meeting, which was a very casual thing which they did make, saying, sir, before this step happened, we did have a meeting with the MD of who was a MNC company who had come down here. We had a meeting, we had agreed upon all these things. We did not document it. There's no minutes. Nothing of that was circulated, and the entire thing has gone wrong. Now, this was a fact which we noticed. We brought it out in our notice. We took a chance. Luckily, when the reply came, they said, yes, in this meeting, this was not discussed. So at least it established the fact that there was a meeting. And then the other sequences clearly showed that our client had been cheated. It was a fraud committed. So they had not accepted the notice. Had I not written about this notice, about this meeting, I would never have been able to pin them. The moment the criminal case had been filed, based upon this meeting, which they accepted that they were all present, matter did get settled. So you must go with an open mind, even if it's the weirdest of things that the client is saying to you. You start discarding things later.
Okay. So, sir, as you said that, you should choose your words wisely and, if you're writing an article. So what if you make a mistake in the article and then it's published? So how do you correct that?
You made a mistake, you're a human being. I think you should apologize for that or say, sorry, that it's happened, in case it's brought to your notice. And you can do anything about it. You can't do anything about it, be careful the next time, that's all. Accept it, you have made a mistake. Don't run away from saying, no, it's not a mistake. I think it was some type of error, nothing like that. It's a mistake. Yes, I was careless. Or yes, it missed my attention. Be honest and upright about it. That's the best way to face it.
So there are multiple questions coming up, but I guess it's time. I mean, it will never end, the questions and the answers, because, listening to you is such a great pleasure. So I guess I should end the webinar, and I'll personally message them if possible. I'll get the attendance list and message them the required questions answered. So thank you so much, sir, for accepting this invitation and coming and speaking about legal research and writing. I'm sure it would be helpful for all of us over here who have attended this session. Ma'am,
thank you, Deep Shivan. It was a pleasure interacting with you all. And
thank you so much, sir. It was such an honor talking to you. Thank you so much.